Thank you, Justice Long, for your wonderful, thoughtful, and brilliant words. Thank you very, very much for raising awareness on this topic. Welcome, everyone. Thank you so much for joining us at our 12th Annual Jewish Law Symposium. It's great to be here, great to have everyone here, and great to get to the wonderful panel that we have just in a moment. You know, they say the difference between a Jewish pessimist and a Jewish optimist is that the Jewish pessimist looks around and says, you know, the world's falling apart and everything's terrible. And you look at Washington, what a mess, and foreign policy around the world, despots and dictators, it's terrible. And Israel, oh, don't get me started on Israel. Things are so bad, the pessimist says, they couldn't possibly get any worse. And the Jewish optimist says, yes, they can, yes, they can. You know, this past year, it's interesting, I came up with this relevant and timely topic addressing harassment many months ago, and at the time I had an inkling of, will it still be timely in September? It's still timely in September. And every day I'd say, well, this will be a good clip to show someone of prominence, of stature, that was taken down by these allegations. And then a week later it was like, well, we could do this clip instead, and this clip instead, and it doesn't stop. And we have, just this week, it's Les Moonves and Jeff Fager. And it's really one thing after another. But, it's a complicated topic. And it's a topic that has a lot of nuances. It's a topic that's hard to necessarily talk about with each other. We all come from different places and have differences of opinion on the matter. And tonight I'd like to get into it a little bit. And I'm very happy to have the panel we have to discuss some of the nuances related to whistleblowing, to standing up and speaking up on matters that are difficult to talk about, to get into the topic of NDAs, non-disclosure agreements. Do they have a place? Do they not have a place? Should they exist? Should they not? And most importantly, as we'll wind down the program later, the topic of second chances. It's a time of repentance, the days of awe, Yom Kippur is approaching. Do we believe in repentance? Do we believe in forgiveness? How does that relate to the Me Too movement? What do you do with people that have done terrible things? We'll talk about that and glean the insight from our wonderful panel, Rabbi Yaffe, Karen Kessler, Neil Mullen, and Rosemary Alito. I'd like to begin with a video clip. This is from LA, so it's not a New Jersey story. It's from a few months back, but it kind of puts together all of the issues that Justice Long has discussed related to a real-life news story. Let's roll the clip, please.
From the largest district attorney's office in the nation, where 1,000 lawyers are sworn to prosecute criminal behavior, an email to DA Jackie Lacey, an alarming allegation. I am reporting a crime of sexual assault by one of your deputy district attorneys. This email details how a deputy DA became a whistleblower, alleging sexual harassment of a female coworker by a male supervisor. What's more, in court documents, the whistleblower says that raising the alert has made her a target, writing that, I have cooperated in a County of Policy and Equity sexual harassment investigation, and because of my cooperation with that investigation, I have been retaliated against. Los Angeles County District Attorney Jackie Lacey denies retaliation against the whistleblower and bias in the plea deals.
We checked that out up and down and discovered it just wasn't there.
About sexual harassment in the workplace, Lacey says, no question, it exists. She was once a 20-something lawyer facing the men.
As a woman in the office, you dealt with it by trying to ignore it, changing your clothing, hoping that it would stop or go away.
You personally?
Well, sure.
Then the Me Too movement, from Hollywood to the state legislature.
Women aren't going to be silent any longer. They're willing to come forward, and this legislature will investigate.
At the DA's office, Lacey says reports of sexual harassment have increased. As for the actions of the whistleblower in reporting it, she praises that.
That is courageous to do that, because you could, in fact, ignore it, which so many people have done. It's been right under their nose, and they've ignored it and gone on and not done anything.
There you have it, folks. There's the whole topic in a nutshell. But I'd like to begin by asking Neil. Neil, you're a plaintiff attorney. You've been representing people for many years. Why is this such a hard thing for people to do? Why is it hard for people to stand up and talk about things that have happened to them or to others within their company, within their firm? Why is this all coming out now, and why has this been something that's been pent up for so long? Neil?
Oh, that's a lot. Let me start with something Justice Long said. The problem of sexual harassment, as she detailed, is a problem of patriarchy. It extends back thousands, maybe tens or hundreds of thousands of years. Women have been second-class citizens and third-class citizens across the globe and across time. That's why it's hard. We've created a legal system that has significant impediments to women asserting their rights against discrimination. I can do this narrowly and broadly. The Supreme Court of the United States, unfortunately, has repeatedly upheld mandatory arbitration. As a justice of the Supreme Court recently pointed out in dissent, 53 million Americans have been forced to sign mandatory arbitration agreements so that if sexual harassment occurs, women are silenced. Arbitration proceedings that they're forced to enter into when they sign up for employment are secret. If you look at the rules of JAMS End Dispute or AAA, they require the arbitrator to maintain the confidentiality of the proceeding. And when women sign up with for corporate employment, they have to sign in advance of employment often confidentiality, secrecy, and non-disclosure agreements. So secrecy is good for sexual assaulters and harassers. Secrecy is good for Harvey Weinstein. Secrecy is good even in religious institutions where the sexual assault of children occurs. Secrecy helps this problem get worse. Now, Justice Long said, and I thank Justice Long for that very profound introduction. Thank you. Justice Long said it's a problem not for HR, human resources, but for the boardroom. I think that's important and profound. HR is always staffed by people who are caught between a rock and a hard place. We've represented, and I've even had published decisions representing women who are heads of HR departments. When they complained of discrimination and harassment, they were retaliated against and fired.
Who do they complain to?
Exactly. Good question. Here's the boardroom, though. Listen to this. Today's New York Times, the Moonves case. This is back in July after 6 women are reported to have suffered severe, serious sexual harassment. This is what happened in the boardroom. Here's what one board member named William Cohn, who you may remember was the defense secretary under Bill Clinton, said. We're going to stay in this meeting until midnight, if we need to, until we get agreement that we stand 100% behind our CEO, and there will be no change in his status. Here's what another director said, Arnold Kolpenson, an 83-year-old producer who won a Best Picture Oscar for Platoon. He said to the board of directors, I don't care if 30 more women come forward and allege this kind of stuff. Les is our leader, and it wouldn't change my opinion of him. Now, that's the boardroom. That's not the HR department. So we get back to another thing the justice said. The composition of the upper echelons of corporations are overwhelmingly male to this day. The compositions of our state legislatures only have 19% women. If you add up the Senate and the House, there are only 19% women in our Congress. Mexico just voted 50% of its legislature to be women. The boardrooms are dominated by men. The men are in a men's club. Have you been in a locker room? It's for real. I'm a guy. I know what happens. So where do you go? How do you solve the problem? If you're a woman and you complain, what do you do?
We'll get there in a moment. Rosemary, give us your take. You've been in the employment world for a very long time, chair a wonderful, large practice. You're dealing with these issues every day. What's your take?
Well, the question was, why do people find it difficult to come forward? I think in today's world, no one should find it difficult to come forward with a complaint of sexual harassment, whether a man or a woman. Every responsible company has a policy, has a procedure for reporting complaints of sexual harassment. The penalties for retaliating against someone who complains about harassment are severe. And not just legal penalties, business penalties today are severe for any company that permits harassment and any company that retaliates against someone who reports harassment. And I agree, that's the way it should be. And the business community today, in many ways, is imposing even harsher penalties on companies that don't have the kind of culture that Justice Long spoke about, or at least aren't striving towards the culture that Justice Long spoke about. In the legal profession, we see major corporations imposing all sorts of requirements on the law firms that represent them to ensure that all of the law firms that they do business with represent their corporate values. Microsoft Corporation recently announced that it was looking for all of its vendors to have the same paid family leave that it provides. And again, I think Justice Long was spot on in identifying what are some of the reasons why women fall out of the workplace and fall out of the upper echelons of law firms. It's because of their family obligations. So it's not just complying with the law, it's a mandate of success in business today.
Karen, help us out over here. You live in the world of public relations. So you have two types of whistleblowers, and we'll use that word as we relate to the topic of sexual harassment. You have someone speaking up about themselves, and then there's someone speaking up about the culture that's going on within their company, or speaking up for something that's happening to other people in the firm. What are the risks involved? Someone calls you up and says, I know this dirt, I know what's going on within my company, I'd love to stop it, but what's going to happen to me? What happens to my future career? What do you say?
It's tough. And listen, nobody wants to be Linda Tripp, and that was sort of for the longest time. That was the image in the public mind of what it meant to be a whistleblower. It's not that way as much anymore, but it's still tough. And it's very tough for people to think about when you do want to report this, where do you go? And you have to have, am I allowed to use this word, rachmanis? You have to have, in this crowd, am I allowed to say that? You have to have rachmanis for the people that are the HR people, because they did not go up and learn their profession to be sex police. And now, all of a sudden, they're being told, you have to educate, which some of them are able to then hire firms like Rosemary's to come in and educate, or some of the firms that are out here today. They have to police, they have to anticipate, they have to punish, they have to reward, they have to communicate. They're not ready to do any of those things, in my opinion, from the companies that we've worked with, and that's a huge problem for people that want to come forward, because that's not a place of safe harbor for most of them, because those people are not prepared to talk about it. And that's a really tough deal for people that want to come forward.
When someone comes to you and says, I want to speak up, but I'm worried about my future career, what would you tell them?
Well, usually they find a lawyer first, and the lawyer finds us. It's usually how it works. But it's, it used to be, listen, it used to be that all the time, the women that came forward were told that if they had a credible case, how much money, and you're getting out of here, and your career's over, and go home and sit on your money, and that was the end of their careers. That's what it was. Now what happens sometimes is that when it's credible, the men are told, you're getting out of here. But we often are told, see how you can frame this so that it doesn't look like he's leaving for the reasons in which he's leaving. Well, when he's being told to leave and people are not told why he's leaving, then that's a chilling effect on all the other women that have the same kinds of stories and have more in those kinds of operations. It's very tough. It's very tough. And listen, I will say, I know we're supposed to talk on a legal level and not on a personal level, but there's not a woman that's sitting out in this audience today, especially those that are not somewhere near the age that I am, that can't tell you that this started for them when they were in their 20s and extends to them even today. We all have those stories. There's not one of us that hasn't been impacted by this. Correct?
Oh, that's true. And what we want to end, and which hopefully we are ending, is that women of my generation felt like you just had to deal with it. And the women of my generation, to succeed, dealt with it. And that's changing, and that attitude should be totally eliminated.
It's
that
moving.
We all agree on.
I don't know if it's going to eliminate in our life, but it's going to move. Hopefully it's going to move.
Rabbi Yaffe, let's ask you over here. The Jewish perspective, Jewish law, we're talking about whistleblowing, we're talking about people standing up. Is there a moral obligation for a person to be a whistleblower? Does Judaism or Jewish law, Talmudic law, consider it to be an obligation for someone who's aware of other people in their workplace being harassed, being hurt in whatever way it is? Can you say, last year actually we had a discussion about medical ethics, and we used the principle of chayecha kodman, that your own life comes first. And when it comes to saving lives, you're allowed to save your own life before saving someone else's. Can a person within a firm or a company say, this is my career, it's my life, I don't want to get involved. I don't want the headache, I don't want the hassle, I know stuff, but I wasn't asked, I'm not going to offer. Rabbi.
So first of all, there actually exists an obligation, even before we get to the argument that sexual harassment is far more serious than the first point. But there's a concept of hashavat aveda. Now, we often think about that of giving back means to return a lost object. And we often think about that in the context of if you find someone's wallet, so find the license and give it back. But in truth, we're obliged to make sure that someone isn't suffering a loss. The obligation to speak out about doing business with someone who may swindle you is hashavat haveda. The obligation to warn people against buying shoddy merchandise is hashavat haveda. All the more so when we see two things with regards to what sexual harassment usually deals with. First of all, that the Talmud is replete with allusions that suffering embarrassment, shame, insult, denigration is worse than financial loss. No, it's even if someone was going to lose money, if I don't tell the truth about the dishonesty or perhaps the discrimination within the workplace where I'm not paying someone what I should pay them, I'm obliged to speak out. This isn't saving your life, because even if you're retaliated against, presumably this isn't the branch of the New Jersey business world that gives you cement shoes, okay? So you're not going to lose your life. You may have to find another job. This is an absolute moral obligation, all the more so when we're dealing with insult, shame, embarrassment, denigration, which the Talmud clearly says in multiple places is worse than losing money, because you can't ever replace that sense of dignity, that suffering. And the Talmud compares it metaphorically, but in a very powerful way, to murder. And on top of that, if you're actually dealing with the type of sexual harassment that Justice Long spoke about, this where there's actually pressure for sexual access. So any kind of forced sexual access, the Torah is quite explicit. It says it's literally the same thing as murder. As a person arises against their fellow to kill, to take their soul, so is this matter, to the extent that saving someone from a genuine sexual assault is considered to be the same law as saving someone from murder. If I see someone attempting to murder someone and there's no other way to stop them other than to kill them, I must kill them. And if I see someone sexually assaulting someone in the full sense of the word, and there's no other way to stop them except by killing the assaulter, Jewish law mandates that I kill the assaulter. So this is a very, very big deal. Granted, not every assault rises to this level, but there's a continuum, and Jewish law recognizes continuums. So anything that involves the sexual exploitation or denigration of another human being, from the perspective of Judaic law, is considered far more serious than the monetary savings, the saving of someone's property that I must speak up about, no matter what the consequences. All the more so when you're dealing something which shades to the level of gross physical assault and murder, and certainly in terms of the emotional costs. As a pulpit rabbi, you work together with counselors, and the costs of this kind of abuse are innumerable, and I think several of our presenters mentioned this idea of dealing with it. But what cost did that dealing with it come? And so I would say that in this case, there's no question that you have to blow the whistle, and
you have the moral obligation.
We have this belief that in the end, our sustenance comes from the Almighty. You have to have a little bit of faith and blow that whistle loud and clear.
Okay, very good. Couldn't agree more. Now, Rosemary, let me ask you a question. I've spoken in the past year to a lot of employment attorneys, and they bring up a disturbing fact. I don't know what the numbers are, the percentages, and I'm interested in hearing what you say, of disgruntled employees that aren't happy or feel that they're on their way out of a job and raise certain claims of questionable validity, hoping for some sort of parachute to take them out. It's an issue. Let's put it right out there. This is an issue people mumble and murmur about. What's going on the inside? That it does exist. How is it dealt with? And give us your take, please.
Well, I think just like any kind of claim, there are some very serious, very legitimate claims of sexual harassment, and they're dealt with one way. There are manufactured claims of sexual harassment, just like there are manufactured claims of personal injuries or any other kind of claim, and they are dealt with differently. It creates tremendous issues in dealing with these because you can't assume, just in the past, you can't assume that everyone making a claim is lying or making it up or has some other ulterior motive. That's totally unfair, and I think we're getting past that. But we also, at the same time, can't let the pendulum swing completely in the opposite direction, where we give total credence to every complaint of harassment that's made because some of them are fake.
Neil, I'd like you to respond to that.
You know, I've read hundreds, maybe thousands of cases published and unpublished decisions of courts across the country in my 38 years. And I don't recall a case, my partner Nancy Erica Smith is here, where a judge ruled that a case of sexual harassment was manufactured. I've seen decisions where judges say it doesn't rise to the level that the law has imposed for sexual harassment. I've certainly seen federal judges, mostly men, find that. But, you know, I'm racking my brains. I suppose there's some case out there. And let me say this. In our 38 years, we've handled hundreds, maybe well over 1,000 cases of sexual harassment, maybe several thousand cases. And I can remember only two circumstances. We vet all our cases. I like to think the courts and the lawyers know that about us. We examine our cases with great care. I've only found two cases that we took that we later realized the woman was lying. In both cases, it turned out there was a consensual relationship that went south, and the woman then turned it all around and said sexual harassment, where we found indisputable, in one case, videotape proof. Two cases out of a couple thousand, maybe 1,500. So I think a woman has to be completely insane to falsely allege sexual harassment, because the retaliation, the wave of resentment she's going to get is enormous, and I think women know that. So I think that the workplace itself, because it's dominated by men, dominated by the attitudes we've been discussing, roots out false claims. Women instinctively know that would be crazy. It'd be crazy to reap the reaction you're going to get with a false claim. So I think it's a non-issue. I think it's a shiny object that distracts us from the very serious problem of massive, pervasive sexual harassment. It's so insignificant, in my opinion.
Karen, let me ask you, Neil mentioned consensual relationships and the ethics of two people in a workplace where, as Justice Long mentioned, there is a power struggle and the power is not even, employee, employer, those types of relationships that choose to want to have some sort of consensual relationship. What do you advise? They probably don't come to you beforehand and ask for advice, right? But
no, but I would
give
say,
us your take of some of the issues. There may be couples married. There may be couples married here that met in the workplace. It is something that does happen. And,
well, increasingly,
hopefully they were single at the
right.
time.
Increasingly, the lawyers would tell you that there are HR firms that now have a policy where you actually have to sign and say, I am having a consensual relationship with so-and-so, and put it in the file, and that's the case. I do think that there's still a stigma to that. I do think that people are still hesitant to do that, but that is an increasing kind of thing that we have seen. I think the biggest question is, someone's idea of consensual may not be someone else's idea of consensual. So the boss's idea of consensual, which is what we hear almost all the time, we either hear it was consensual or I was mentoring her. Those are like the two greatest hits we hear. So your idea of consensual and my idea of consensual are not the same. So our basic philosophy that we share, and it's always too late, is when she works for you, that's not consensual. When you sign her paycheck, that's not consensual. Now, that said, we say if you are looking for unsolicited romance, why don't you go to OkCupid, where you can harass as many women as you want. But if you are going within your workplace, you better be darn sure of what's going on. And to Neil's point, and to Rosemary's, is, oftentimes, truly, what does start as consensual can turn south incredibly easily, given the complexities of the workplace today. So, for every reason, it is fraught with difficulties, and for every reason, when we do get involved in some of these matters, there is a sense that initially there was some attraction, or there was something that was going on that was not incredibly, the women did not object to, or the women were somewhat open, or the women. But it doesn't matter, because it is within a moment, it can flip. And that's when, you realize that somebody's really gotten themselves into trouble. That's for when people are both available. When one of them is married, and it is usually the boss, and they are in a consensual relationship, they think, or in a relationship with someone that reports to them, that's when it gets incredibly complicated. And that's when these cases, the first thing we're always told is, I don't want my wife to find out, which is like, it's a little too late.
She's not the one that consented, right? Right, okay.
Right. And we've actually, the craziness is we've actually been asked to even write talking points of how someone could talk to their spouse, because a case is about to go public, and they want to know, how should I be able to tell my spouse what I did?
They don't say, Karen, why don't you call my spouse and tell them?
No, but we want to say, for all of you matrimonial lawyers out there, you're the ones who should be taking that case, not me, right?
Rabbi Yaffe, help us out over here. The power imbalance, employee-employer. What does Jewish perspective, the Bible, talk about the obligations of an employer to an employee, and the boundaries that are between an employee and employer to see to it that employees are not taken advantage of in any context? Give us a little snapshot.
Well, first of all, what we're going to talk about, I think you're going to raise later, the boundaries that Jewish law imposes on all unrelated men and women, which essentially are no loaded words, no touching, no being alone in a situation where you're not going to be disturbed.
Sounds like Mike Pence.
What?
Sounds like Mike Pence.
Well, I was thinking he must have picked up some Talmud somewhere, but
he's Jewish. Who knew? Maybe he's Jewish. Who knew?
Well, but actually, I should say that these ideas are part of Judaism's universal heritage to the world. These are not matters pertaining to how you pray on Yom Kippur or kosher or so on, which are exclusively Jewish ideas. These are part of Judaism's gift to the world, and part of it is precisely because there exist these type of imbalances. There's even an imbalance of physical strength, right? So there is this concept that you have to create a safe and solid space around you so you can interact with something socially, economically, financially, politically, etc., without there ever being crossed wires that a close working relationship somehow becomes sexually charged. The Jewish law is quite clear that you have to avoid suggestive words, you have to avoid inappropriate looks, you have to avoid, and by the way, because there's a power imbalance, Jewish law imposes this onus primarily upon men. It is incorrect to say that Judaism has that there's something about modesty imposed on women. The Talmud in Tractate Bava Batra is explicit that if you think you're going to see women, this has to do with washing clothes. They used to wash clothes by the river, and it took a lot of physical work. The Talmud says, you don't tell them where to go wash their clothes. You take the circuitous route. This is a set of laws imposed upon men and women, primarily upon men, because of the power imbalance. In other words, if there is any sense in an economic business relationship that you're somehow want some kind of intimate relationship out of it, you've already violated the laws. You've already violated the system that Judaism sets up, and not just for Jews, but as good advice to all human beings to avoid these intrinsic imbalances. And there's more to be said, but I think this is a good beginning.
Even if you aren't going to act on them?
What?
Even if you're not planning on acting on them?
Yes, there's a prohibition against inappropriate looking. There's a prohibition against...
How about lusting in one's heart?
What?
How about lusting in one's heart?
One cannot control what comes up into one's heart. If you start building, in other words, you can't control all of a sudden when a shoot of grass shoots up, an inappropriate weed grows in your heart. But if you water it and you cultivate it and you coddle it, then you have a problem. Then you have to control it.
We need the pesticide to keep everything under control.